Professor Kleinman and I will try to pay attention to see if anybody is making any reactions, if they have something to say. You're welcome to just say, I have a question. If you have any questions as we're going through everything, it doesn't necessarily have to be specific to what you read in the book. It could be how it applies in the real world. So that is going to be my goal today. I'm going to cover most of what that PowerPoint outlined. You guys had a few objectives, and I'm going to give you examples of how that impacts our real life and what it looks like in the workforce rather than in a textbook. So just a little scholastic background on me. I also started at a junior college. I put myself through school. I was an older law student that just kept going. So after the class, I'm sure Professor Kleinman will share my LinkedIn page with you guys. If you have any questions, just even about what school is like, how to transfer, please provide any advice or insight that I can. I am from Los Angeles, born and raised, so it is a little bit different than Arizona, but I did live in Arizona for 3 years. That's where most of my work experience came from until I graduated law school and moved back to California. So with that said, does anybody have any questions before we start? No? Great. All right, so your first objective is to cover what is judicial review. So judicial review generally is a legislative act or an executive act, excuse me. Legislative is an act of Congress. So when Congress decides that they want to do something, executive act is when the president decides that he wants to do something. Generally, if something is put into place and someone is offended by it, or they're like, hey, this is in violation of my constitutional right, they will then file a court case. There's, you think of it like a pyramid, there's a lower level court and it kind of builds its way up. With the Supreme Court over legislative and executive acts, they kind of have original jurisdiction, so you can bring it straight to the Supreme Court, and it has to be approved essentially by the justices that sit. But with that, with the judicial review, we don't have too many cases that are recent, but we have some things that are happening currently in today's day and age with the political climate, especially in the past 5 years. Can you guys think of anything that would fall under a legislative action or an executive action, or any cases that may be considered for judicial review?
And
Can you guys just shout out the answers or raise your thumbs up, whichever you prefer.
You think about things where maybe the president has passed an order that didn't go through the typical process, or anything even locally statewide that Governor Ducey may have done, or mayors, or with the coronavirus. Can anyone think of an example where there was just an order put out that we as citizens were forced to follow?
Well, like the gyms closing down, and then Mountainside filed a lawsuit to contradict Ducey's order. I mean, would that qualify?
That would definitely qualify. So we have Leigh back. I'm sorry, I jump in sometimes, Leigh. I'll let you take over.
So, I know it froze on my side. I was like, everybody's frozen.
In case you didn't hear, she was talking about the order to close down all the gyms when other businesses were allowed to be open.
Yeah, so that's a good example of like state legislative action, right? When we think of federal legislative action, one of the most recent things that comes to the forefront is the DACA, right? Where Department of Homeland Security was essentially saying Trump disguised it as Department of Homeland Security trying to stop DACA. The University of California Regents was like, nah, we're not going to be okay with that. And that went to the Supreme Court. So that's an example of what judicial review would look like. Another case that happened in, I believe it was 2018, is Murphy versus the NCAA, and that was surrounding sports gambling. So sports gambling is a big thing right now, right? FanDuel, DraftKings, what that looks like, especially with the internet and how people are making money, what you can bet on, what you can't bet on. So with that case, there is an act. It's the Amateur Sports Act that's different than the Ted Stevens Act. And essentially, they were saying that this act protected colleges and that you could not sports bet on colleges. Well, the Supreme Court said, no, that's a state by state thing, that the United States as a whole does not have a ban against gambling. Each state gets to determine the type of gambling that they want to have in the state. And that was really impactful for Jersey. That's where most of the sports gambling is housed right now, is in Jersey. You have some in Vegas too, but particularly with DraftKings, it's on the East Coast for the most part. Do you guys have any questions about that? No? All right. So we're going to kind of transition into jurisdiction and what that looks like. Oh, yes, go ahead. I saw a hand. Austin.
Yeah, I had a question for whenever that review goes through for things like whenever southern states were passing restrictions on abortion, do those have to go through a review?
So they don't have to go through review. Usually what happens is it gets appealed. So you'll start at a trial court, and we're going to I'll go over this a little bit more in jurisdiction, but you'll start at a trial court depending on what the issue is. Usually when it's constitutional, you'll go into a federal court or a district court, and you're going to say, hey, the state has this thing that's violating my constitutional rights. And then the court has a ruling and they say, no, we're not violating your constitutional rights because of X, Y, and Z. And then that plaintiff will usually file with the Supreme Court, and it's a process because you have to file with the court and say, will you please hear this case? We think this case is in violation of the Constitution. Then the Supreme Court says yes or no. And then once they say yes or no, then you go into like the actual presenting litigation.
Okay, thank you.
Yeah.
I just have
And
like a follow-up question on that piece. So when they say no, in some instances, I've seen that they'll write like reasons why and say, fix this and try again. But are there times where they just say flat out no, and then that's it?
Yes. So yes to both. Sometimes they'll say this was not presented correctly. This was not the right argument. You don't really get the chance to try again. If that makes sense, it's usually the plaintiff is bringing forward a cause of action that is not accurate. So somebody else would have to bring forth the litigation. It's not like when you get a test and your professor's like, fix the answer and I'll give you credit, that type of thing. You would have to start like a whole new litigation with new case law on a new basis. Sometimes it's the same plaintiff and sometimes it's not. Usually it's not, but there are definitely cases where the judges are like, nope, too bad. We're not going to hear it. This is clearly fine. And you can see some of those on the Supreme Court website. They publish all of that. There's actually a lot of stuff that comes out of the Supreme Court that we don't hear about. Those are good questions. All right, so transitioning over to jurisdiction. So in order to bring a case in court, you would need jurisdiction, whether you're bringing it in a local court, a county court, a state court, a federal court, an appellate court, you need jurisdiction. And based on what court you're filing in, the jurisdiction is going to vary. But in a general sense, you are going to bring the suit in the court where you have standing, right? So you are the person that suffered the injury, and it needs to be something that is actually happening. So it can't be like a speculation. that was one of the biggest things with the abortion litigation, right? When Roe versus Wade got passed, because the woman was pregnant, but by the time the Supreme Court heard the case, she already had the baby, right? So they tried to argue and say, well, it's no longer a real case in controversy because she already had the baby, so it's not a problem anymore. But the idea was, well, now it's still a problem because anybody can get pregnant any day, right? So you want to make sure that controversy is live, or that it's actually going to happen, versus it being a moot point or it can't really occur anymore. And so with that, you also do something which is frowned on, but it's called forum shopping, especially in the business world. You want to go into a court that is going to find in your favor. So if you're a plaintiff and you're like, I got hurt in California, and I know California is very plaintiff friendly, I'm going to file in California. Versus if the person lives in Arizona, that defendant might say, Arizona is very touch and go hypothetical. It's a little more complex than that, but a lot of times businesses will forum shop. They like to get things in Delaware. Usually that's where companies are incorporated, because the laws are a little bit different and they're more corporate friendly in Delaware. So with those different courts, in order to bring a suit against the defendant, the person that you're saying, hey, you hurt me, you would need personal jurisdiction or subject matter jurisdiction, depending on the court that you brought the case in. So with personal jurisdiction, you have jurisdiction over the person or over the property. And usually that's determined by minimum contacts. If you're a corporation, it's where you're incorporated or where your principal place of business is. For bigger companies like Amazon, I like using Amazon as an example. They have businesses across the nation, so you're more likely to be able to bring a suit anywhere with Amazon versus a place like Nike, right? Even though they sell to other states and they have retail stores, if it's a corporate type of litigation, you may have to bring that in Oregon.
An interesting little side note to go back to what Leigh was saying as far as like with the Roe v. Wade and abortion. There was a time where colleges were trying to use affirmative action to keep their student body a diverse group. And there was a law school actually up in Michigan that a couple of white male students who are applicants felt they were denied simply because they were white men, sued to say we should have been accepted to this law school. And the whole process took over 3 years to do. And in that time frame, the law students that were suing went to a different law school and graduated. And the courts finally kind of said, well, there's really not a case here because policies have changed in the law school and all the people that are complaining have already graduated law school. So they don't have that standing to say they were harmed anymore, because even if they won and they were admitted, you can't get 2 law school degrees. So the timeliness sometimes is an issue in determining whether or not a case can go forward. And if there's a solution that happens inadvertently during the process of litigation, the litigation may become useless or, for the technical terms, moot. So let you have it back again.
Yeah, no, that's a very good point. So the other type of jurisdiction is going to be subject matter jurisdiction. And there's 2 types of subject matter jurisdiction: federal question and diversity. So diversity is pretty simple. It's where the plaintiff and the defendant are residents of different states, and the litigation, right, the amount that they are requesting as the remedy is over $75,000. Federal question is, there's 3 different types. So you can have federal law, right, which is like congressional legislation. You can have constitutional law, which we all know as our Constitution, your amendments, your Bill of Rights, and then treaties. So there's treaties that the United States has in place. And that one, a lot of people forget about sometimes. They're like, oh, it's legislative action and we have the Constitution, but treaties are just as important. So that's why you'll see a lot of Indian law cases coming through the Supreme Court because they have jurisdiction over that. Or you'll see them in district courts and the federal courts as well, but usually they get bumped up to the Supreme Court because of the types of matters that come before the court. Indian law is very complex. That was one of my specialties in addition to sports law and business. So we can talk about some of the different things surrounding Indian law and what that looks like as well, particularly as it relates to jurisdiction. But for right now, you have personal jurisdiction, which is brought into usually the state courts, and subject matter jurisdiction, which is usually brought into the federal courts, like the federal district court. And those are the types of matters that they would hear. And again, you have essentially a pyramid, right? So you have your trial courts at the bottom, then you have your appellate courts, your district courts, your federal courts, and then your Supreme Court at the top. So depending on the type of case it is or what the nature is of the lawsuit will determine how much of that pyramid you can climb. So I know that you guys covered some of the internet transactions. Yesterday, one of the things that we talked about was Amazon. So a long time ago, when I was a kid and you had to plug your internet into the computer and it made like the annoying dial-up sound, right? A lot of websites were not selling things on the internet. You could go on the internet, you could research stuff, but it wasn't business like it is today. So that's kind of where these standards came from, where it's like, well, are they conducting substantial business? Or is it just interactivity? Or is it informational? Are you reaching out to them? Are they reaching out to you? That's what it looks like. But something that's a good example for internet transactions is recently, within the past 7 to 10 years, Amazon had to start charging tax. So Amazon used to not charge tax. And then their business got too big, right? And the federal government's like, no, you guys can't conduct this business over the internet and not have taxes. And then Amazon started to charge tax, which now sucks because based on where you live or where you get the product from, your tax is gonna vary. And that's one of those things with jurisdiction, right? Based on where it is, let's say Amazon ships you something and you get hurt by this product that exploded and you want to go and sue Amazon now, well, where are you going to file that case? And so that's just kind of some of the differences and the different histories behind internet transactions. Do you guys have any questions?
I did have a question, kind of like when you were talking about subject matter. If I heard you correctly, you said subject matter would be anything like over 75,000, right? Or did I understand that wrong?
That it's correct, but there's another piece to that. So the plaintiff and the defendant have to live in different states. And then in addition to that, the case has to be over $75,000.
Got you. Okay, it was that piece.
Yes.
Okay.
Yes. And so like that kind of goes back to if you're a corporation, right? Because usually something like that, you're going to see, I go to Amazon headquarters, I fall down their stairs because their stairs don't have yellow piping on it and it's supposed to. And I live in California, but Amazon's principal place of business and they're incorporated in Washington, and I'm going to sue them for $76,000, right? That would be something that we could pull into federal court.
You screwed up my examples. Is Amazon based in Washington?
Yeah, Seattle.
Wow, okay. I screwed that up last time when I was giving that as an example. I used California. I figured they were all in the Tech Valley.
So they have headquarters in California, but it's like their main warehouse.
Okay. Their operation is in Seattle.
Google is in Northern California. And I think Amazon is planning to move to Northern California, but with all the fires and the increase in taxes, I think they'd be better off staying in Seattle.
See, even the teacher learns something every day, so not bad.
Yeah, they have lots of business IT jobs. You guys ever looked at their job board? They have something like 5,000 jobs posted right now. It's insane. So much stuff.
They're bringing a whole new office complex thing here to the Phoenix area in the next year. So
Mm-hmm. They own the internet. They have like their own server something. I don't even know what it is. Somebody explained it to me one time, but they basically have their own internet, which is mind-boggling to me because the internet is just like huge. But digressing back to our lessons for today.
I do think they just started selling used books. Did we freeze on Leigh? Are you there still?
Yeah, you froze. Please say that again.
Oh no, I said to think they started by just selling used books and now they're what they are. That's crazy.
Very crazy.
All
right. So one of your other objectives is discovery. And we talked about you have discovery and then you have e-discovery. Now in the day that we live in, right, you have everything is accessible via the internet. So most of the time during litigation, we're not going to have those big boxes of paper like you see in the movies where they're reeling in stacks and stacks of bankers' boxes filled with papers that people have to sort through. You might. I don't want to say that's never going to happen because it still happens, particularly with forensic accounting and different things where people have to maintain their receipts and they have to have that paper trail. But generally, everything is moving to an electronic format. So you have depositions, which are you bring somebody in, you essentially ask them to testify, right? And they testify in person, so it's not in a courtroom, it's just with the two attorneys and the person answering questions. You have interrogatories, which is somebody gives you a sheet of paper with a bunch of questions on it and you have to fill it out and swear that you're telling the truth. And then you have request for production or information. That is more where you're going to get the e-discovery types of things. So cell phone records, emails, business transactions, contracts, agreements, those types of things in civil litigation. In criminal, right, you might have that forensic type of tracking where somebody is going to pull your cell phone. They're going to say, no, we're keeping your cell phone and we are going to look through this and see what's on here and if we can find anything incriminating. Yesterday we talked about some of the ways that things are stored on your phone. Like when something is deleted, it's not actually deleted. It's there forever for somebody to find. So you want to be careful what you send out. One of my favorite memes is email like it's going to be read out loud in court one day. That is my favorite meme ever because it reminds you before you send something, make sure that you know what you're sending out because there is a chance that it will come back to you. So those are the different types of e-discovery when you think of it in a sense of today in 2020. Any questions?
Yeah, I deal with discovery in my business every day because I own a company for the Department of Child Safety. So my staff constantly get subpoenaed, constantly, like what you say, like email, like it's going to be read because it will. So like we get subpoena for records on a weekly basis, like constantly. But one thing that has always confused me when it's like it's 2020 and we all know that like what we put on social media, everyone can see it, just assume everyone's going to see it. Where in one of my ethics courses, they were saying that like attorneys or people can't, like, say, make a profile to go on someone's profile to get information, even though it's like, in my opinion, like technically public. And I never really like understood how that could be a violation, or sometimes then how I have to have my staff protect themselves, that if, like, since March, when we had to go virtual on visitations for a while, for example, the state allowed my staff to make like business Facebook pages, because some of the parents have to use like Messenger so that they could have the virtual visits, for example. But then that means that my staff are connected with the client on Facebook via their business profile. So if they saw something suspicious, is it like now we have to be concerned about that, about what they're saying is, I don't know, admissible?
So that's a pretty good question. Think in relation to your ethics course, and I'm speculating, but the way it sounds is that they don't want you to create a fake profile to attain the information, right? Because that's not really ethical. Now, if it's something where it's like your business profile, and you're connected with them and you see it, it's the same thing as if you are out on the street and you see one of your parents do something to the child, right? That's the exact same thing. And you, as an advocate of the court and an advocate of the child, have that obligation to report, right? So I think that's the difference between the two. One is intentionally being misleading by creating a fake profile to attain this information, versus something already being up and you're seeing it. So when I was at the United States Olympic and Paralympic Committee, part of what I would review was the conflict of interest forms to make sure that the staff and the board were conflict free. And if they were not conflict free, that they disclosed their conflict so that everybody was aware of it when making a business decision, so that somebody wasn't making a decision in their own personal interest. And the way I did it was I would just do a basic Google search of their name with the type of sport that it was. Very simple. A lot of people's LinkedIn pages are public, right? You can see everything on there. There's newspaper articles out there. That's public information. So when we would have these conversations with the CEOs, they're saying, well, where did you find that? How do you know that? It's on the internet. It's on the first page of Google. Like, I'm not doing any type of real fancy deep dive. I literally just Googled the person's name with the sport, and whatever pops up on the first page is the results. And if this violates your policy based on what you had these people sign, I'm going to tell you. And so that's where the ethical difference is. I'm not trying to be sneaky and do like hours on end deep dive, look at their Instagram page and find out what they're doing. Just basic, what's their name? Let's see what they put on LinkedIn. Oh, look, here's a newspaper article about them. Let's read what it says. So that's kind of the line. Does that make sense?
Yeah, that totally makes sense. And then I guess I'm just still thinking, like, it makes sense on that side, like they know it's up front. And at the same time, I still remain a little bit like confused as far as like, so if say, for example, one of my staff wanted to sue because they got injured or something, and for like all this money or something like that, and then so I hire, you know, my attorney to go, and like I feel like attorneys a lot of times a piece is research, right? So I guess I don't know. I guess I don't know how fair it is that if they're, say, going and running and jumping around on their social media and like people know that, but because you're technically not friends and you can't see it, like I guess like in my opinion it would be evidence is evidence, and like so why exactly would that matter how they got it? If you put it on the internet, that it's on the internet. Like
I'll help you with that one, Candace. If you have a good reason to believe, like, because say someone tells you so-and-so got injured, but they're doing Instagram live videos, Facebook live videos of them water skiing, snow skiing, goofing around on trampolines. You can subpoena access to that through the court system, where the court would be saying to the people, you need to give over this information because we have a reasonable belief it's there. The problem where you get with the fake IDs with social media, it's like almost like creating a fake identity, walking into a bank and saying, I want to open up a bank account. You can't do that. That's fraudulent. Making up a fake Facebook page or Instagram page to get information by deceiving or defrauding the person, that's where the illegality comes in and the wrongfulness of it. And that's what they were saying in your ethics class, versus going through the legal means to demand during the discovery. You can demand they turn over access to that or screenshots of it, because you say, it's my belief and understanding that on August 12th, you posted a picture of you water skiing up in Lake Havasu. They would then have to disclose that for the court proceeding. They can't hide that from you. All righty, I'm gonna just quiet again.
Yeah, that's very helpful, and I think sometimes, particularly when it comes to children and child services, right, it can be trickier. So I understand that aspect. As Professor Clemens said, I practice family law, and so we deal with minors a lot and different social workers and things that can be said, can't be said, what you have to disclose, not disclose. So it can be tricky, but it's good that you're thinking about those things, right? Having the awareness is half the battle. All right, so the last objective that we have for today is alternative dispute resolution. So your PowerPoint gave you 3 types: negotiation, mediation, and arbitration. So negotiation is essentially when you do just that, right? Like, I'm sure each of you guys have negotiated at some point in your life. You've haggled with a store dealer. You've made an agreement with your parents. That's negotiation. The way it works in alternative dispute resolution, so for a current example, right, the Olympic and Paralympic Games were postponed, or all of sports, right, due to COVID were postponed. Well, you have these sponsors that come in and they agree with the sports teams, we are going to pay you X amount of dollars for you to put our name on your jersey, for us to be your premier sponsor at these games. So what happens when you cancel those games? You can't fulfill that obligation anymore. So at that point, the attorneys have a negotiation. They say, we are going to negotiate what this agreement is going to look like now that both of us, or one of us essentially because of COVID, cannot perform. And what does that look like? So for the NBA, with all of those games and the corporate partnerships, right, the attorneys had to go to them and say, we still need your money. So how can we fix this? For some people, the ones that are in the bubble, right, it's going to be easier because they're going to say, well, we can add you to our app. We can add you to the live stream. We can make sure that their jerseys still have the logo on it. We can make sure that when they show the locker room or them walking in, that they have a Coke bottle in their hand or they have a Dasani in their hand. That's going to be a little simpler than those who essentially the season was done, right? Season's done, there's no airtime for them. There's no fans. So what is that negotiation going to look like? So that's kind of one of the alternative dispute resolutions in today's real life practice. The next example is mediation. And so mediation, I typically saw through family law. So in Arizona, you're required when you file divorce for dissolution, and you have to go through mediation. It's mandated, you have to go through two. Now, whether it works or not is a different story, but the courts are so backed up. And in Arizona, they also have a rule that a dissolution needs to be resolved within a year. In California, that doesn't exist. So I'm sure you guys are familiar with Kim Kardashian, right? And how long she was married to Chris Humphries and how she was pregnant with Kanye's baby and all this other stuff. And it went on forever. That would not happen in Arizona. They're like, nope, you're doing mediation. It needs to be done by a year. Otherwise, the judge is going to decide that's it. That's why Glory and Brittany Griner had such a easy divorce, because they were on a timeline. You guys have this much time to figure it out. And if you don't figure it out, we're going to decide for you. So with mediation, both parties come in. There's usually a mediator or a magistrate, not necessarily a judge, but somebody who is credentialed to sit and mediate. And sometimes the parties will have their attorneys present on both sides, and they discuss. So it's kind of like a negotiation, but you have a third party in the middle trying to be impartial, unbiased, and say, well, what if we do this? So the mediator can make suggestions. They can't decide for you. Both of the parties have to agree. It's just easier sometimes to have a third head. Do you guys have any questions about negotiation or mediation?
Mediators also are like the ear to the judge as well too, though, right? Like they take notes of the mediation and they have to disclose that, or is that not in all cases?
It depends. It's not in all cases. It depends. If the parties were not cooperative and it has to do with the matter at hand, the mediator can be called for input. But that's more of something that is going to be presented with matters that are for like parenting time and custodial, not necessarily all the time. Like if the parents can't agree on who's going to get what, or if neither of the parents are going to get the kid, and how that works with the guardian ad litem, it's a little more complicated because the mediator is not just a mediator at that point. They're also acting as a social worker. So it's a little bit more complex.
But talk about a little bit, like you watched mediations happen and you saw successful mediations where they reached decisions and reached solutions. How much more were those solutions followed than in family law cases that you saw where the judges ordered things to happen?
Honestly, I haven't seen any mediation that did end up successfully.
Oh, you didn't? Okay.
No. In my experience, I have not seen any mediation end successfully, particularly in family law. Especially a lot of the matters that I worked with, they were very emotionally driven. They were long marriages that were coming to a dissolution because one of the parties cheated on them, or there were allegations of child abuse. So it was not pretty. The ones that were clean, both parties were amicable. We didn't need to go to mediation. It was, you take this, I take this, we're going to sign the papers, and that's it. So that's nice and clean. You're like, all right, let's do this. But in relation to my experience in mediation, I haven't seen it. But going back to the negotiation kind of, and merging negotiation and mediation, right? When I was working at SAG-AFTRA, so Black Panther had or just been released. And at SAG-AFTRA, we're the Screen Actors Guild, so we are the union for the actors. There is a 600-page collective bargaining agreement that the producers sign to. When they sign the contract, they're saying, we're going to use your actors, we're going to pay your actors this much money. And they're allowed to pay them more, they just can't pay them less. So with that, and having the expectation that producers are going to read this 600-page agreement, which they don't, right? We have movies that come out. So with Black Panther, we had a lot of actors calling us and saying, I appeared in this film 7 more times than they paid me for. And there are scenes where Black Panther looped the people. And so the actor's going, wait a minute, that's my face. Wait a minute, that's my face. Wait a minute, that's my face. And they only got paid for the one time where they shot that full day. It may have been a 48-hour shoot, and they got paid for those 48 hours. But every time their face appears on the screen, they get additional money. So then we had to go back and actually sit and watch the movie and count how many times these actors, now we did only the actors that complained we did this for. If you didn't call us, you didn't get paid. But we sat in the actors that called us and counted how many times each actor came onto the film. Then we went back to Marvel and said, hey, Marvel, you need to give us money that they weren't going to catch you, and they did, so you need to pay them. And at that point, we kind of act like a mediator, because you have the actor complaining and the producer not paying. And so what we do is then we say, okay, let's get to an amount that you're comfortable with, because we realize when you're filming, you don't know that you're going to loop this film. It's post-production that you loop the film. You say, we need this to look like this. We're going to cut and paste and loop it. And at that point, the producers honestly just hope that they don't get caught. And then when they do, they know that we're going to come to them and say, you need to give us more money. And we then negotiate an amount with them. And both parties are going to agree to that amount, and then they cut the check for our actors. So it kind of crosses into mediation and negotiation a little bit, because we're negotiating an amount that both are comfortable with, but we're mediating the situation between the producers and the actors.
So if your client is the actor, as their attorney, what is your suggestion to them? Like what part would be in their interest, not to just say, this is the contract, this is the amount of money that I need? Like, why would the actor need to negotiate an amount if we're dealing with a company that's like multi-millions? Why would they need to settle on something else?
So usually the way that it looks, right? I'm an actor, I'm represented by the union, I'm not getting paid. The amount, we'll say, the largest amount might have been $5,000. Like it's not a significant amount of money. So their only other option is what? To go to court and sue. Who's going to spend money going to court and suing? And it's not in their best interest, right, as an actor to stick it to the man, because then they're not going to get hired again. They're going to be known as this problem actor. And so there's a lot of variables that are not necessarily strictly business law. And sometimes as a lawyer, you have to use judgment and say, I realize that this isn't the full amount, but it will get you further by taking this and moving on. Or we can really just push the book and say, nope, this is how much you have to give them and you need to pay it, and that's it, which we have done before. But then we're also relying on them to cut the check. So Marvel is going to be better about it, but some other companies like Mar Vista, or the films that you see on like Lifetime, HBO, those types of things, they're smaller producers. And even though HBO may buy the rights to that product, it doesn't mean that HBO made the film, right? So you're having people that are getting paid like $100 a day, $125 a day, if that. And then we're like, hey, you need to give us $500 more. And then the producers just disappear off of the face of the earth. They also do this thing where they make shell companies. So companies that don't really exist to funnel money through. So they'll say, we're going to have a film called Eyelid LLC, and they'll create the shell company. They'll have any of the investors put money into this Eyelid LLC. They'll pay the actors out of Eyelid LLC. Then once it gets bought by HBO, they're like, oh, we're going to dissolve this business, and the LLC is gone, just like that. So there's no one to go after at that point.
And we learned with the whole Me Too movement how scary it is sometimes to go after movie executives, movie producers, where you would think here's something clear as day and easy to say I was wrong and get their money for that or be able to sue for that. But knowing that it's such a tight-knit industry that the second you rock the boat, there's 10 people that have the same skills and look that you have behind you that can replace you, where then you are not getting to keep your job, and you likely won't be able to get a job anywhere else. So unfortunately, that power structure with people that are concerning themselves with looped images kind of forces them to say, gosh, I'd like the extra $5,000, but if you give me 2,500, I'll settle. Because they want to get something, but they don't want to be that guy or that girl that raises those concerns.
Yeah, I guess I just figure us being in a class that has to do with like business ownership, like God forbid if I ever didn't pay somebody something that's in their employment contract, like I don't know that I would ever get away with something like that.
Oh, sure you could. Everything's negotiable. I mean, is it as easy for you to do it as Marvel? Probably not. But I mean, you have to sit there and say, and insurance companies do this in car accidents all the time. What's the cost for me to hire the lawyer that I've got on retainer, have them do discovery, go to court, do all these things, versus what number could we settle on? What's that cost benefit analysis? And as a small business owner, you can do that also. If someone says, gosh, you screwed me out of $5,000, you can sit there and say, okay, they've got a point, they might be right, but would they go away for $2,000? Would they go away for $3,000? Then I don't have to spend any money hiring my lawyer to defend that. So every level of business should go through this type of negotiation. And if you have business insurance, you call your insurance agent and say, hey, this is what's happening. Their lawyers are going to do that for you also. They're going to say, what can we settle for? Before they just automatically go and try to settle it in front of a judge or a jury.
Any other questions before we move on to arbitration? No? All right. So arbitration is something that actually affects all of our lives every day. And I'm sure that we don't really think about it. If you have a cell phone, in your cell phone contract, you agree to arbitration. If you have a computer, in your warranty, you have a problem with your computer, you agree to arbitration. So all of these, they're called click-wrap contracts or warranty agreements that we don't really read. There is always going to be an arbitration clause in these agreements that say, hey, you agree that you're not going to sue us and you're going to go to arbitration first. And what arbitration looks like is like a very low grade court system. So you have both parties, and then you're going to have a panel of 3 judges. And depending on what your arbitration agreement says, usually the rules of a court do not follow. So you're not going to have as many evidentiary rules or discovery rules or document production rules. But there are 3 judges that are there, and they're going to review both sides and say, okay, this is what it is, and they're going to make a ruling. So the way that looks in the United States Olympic Committee is we have national governing bodies. So the most known example right now, which is not the best example, is USA Gymnastics. So we give USA Gymnastics money for their athletes. And through this, they have a grant agreement that they sign that says, we agree we are going to use this money for these things. if something happens, we agree to go to arbitration with the USOPC. So on the USOPC website under legal, there's actually a tab with all the section 9, 10, 11 arbitration rulings that have been out since 1974, I believe. I mean, historically, all the way, because most of these matters, we don't want them to go to court, right? We just want them to be arbitrated. We want to say, hey, NGB, you did something wrong, and we need somebody to tell us and agree with us that you did something wrong, or maybe we did something wrong, and the NGB is saying, hey, USOPC, you did something wrong, and we're going to go to arbitration for this. Another example of jurisdictionally what that looks like, right, is if you go to arbitration and there's a ruling and you don't agree with it, generally it's going to be really hard to take that into a court, because the court's going to say, hey, you agreed to arbitration. People do it, but they look at it and they say, but you agreed you're going to go to arbitration. So that is something just to be mindful of, and it is an alternative dispute resolution to going to court, which most people prefer because it's informal and it's not going to be as costly. Do you guys have any questions about that?
And the privacy issues, especially with the Olympics, that stuff's important because, again, for bad reasons over the previous years, there were a lot of questionable things being done by maybe some of the coaches and trainers and doctors tied to the Olympics, that settlements could have happened in arbitration that never were made public to warn future athletes.
A lot of that stuff wasn't arbitrated because it didn't fall under our PPA. That falls under the congressional legislation.
Okay.
So the Center for Safe Sport was enacted by Senator Feinstein. And what that does is it actually applies to all youth sports, which most people don't realize. So even if you have a brother or sister in Pop Warner football, Safe Sport actually applies to them. The center just doesn't have the capacity right now to monitor all of that. So their main focus is the United States Olympic and Paralympic Committee as it relates to the children that fall under their jurisdiction, and colleges. But because it's congressional legislation, when that stuff happened, it had immediate right to go to court or to go to a district court.
Gotcha.
Yeah, and it's weird because the way that it hit the media, they made it seem like we were the ones governing it, but we're actually not. It was codified into the Ted Stevens Act, so it's actually part of the act now.
Huh, okay.
Which is why the center is independent. They are its own independent body. So like Candace, that would probably be a great place for you to look if you wanted to go into sports and child services, right? The Center for Safe Sport, that's what they do, is they protect child athletes. They receive reports, they do investigations, they go out and talk to all these NGBs and they're like, hey, you can't do this. By working at an NGB, the USOPC, you are a mandatory reporter. So anytime you hear something, see something, you have to report it, whether it be on our training site or, you know, my sister does trampoline and tumbling and she's a minor. So if I ever saw something at her gym, I would be obligated to report it. So that wasn't covered by arbitration, which is kind of good.
Well, I think unless we have any quick questions, I'm gonna kind of ask you, Leigh, let's see, what do I want to ask you? Stir a couple last minutes of debate. or questions. With the different companies, organizations, entities, government type things that you've worked at, can you, because next week we're going to talk about ethics, and can you kind of give your thoughts on, as a lawyer, as a person, how ethics and the ethical world kind of goes into making decisions you have to make? Like, what's been a scenario where you maybe walked away from a good situation because it wasn't a good situation for you, or something
Sure.
like that?
So I can give a couple of examples. The first one I will give is going to be more career related. So I worked in public defense, which means that I represented people that were alleged to have committed a crime, some of which I know they committed the crime because they told us, right? And actually, this is a great example that I had a client. He at the time was 22, and he was charged with 13 counts of statutory rape. What that means is that he had intercourse with a minor. And when you have intercourse with a minor, it is 1 count for every time you have intercourse with them. And in this particular situation, he was 19 at the time. So it wasn't until 3 years later, 3 years, right? Yeah, 3 years later that the charges were brought. And the way it happened was the mother of the daughter found out that they were boyfriend and girlfriend at the time, and then told the other girl's mother, who was her friend, and it turned out he had dated both of these girls. And at the time when he was 19, the girls told him that they were 16 and 17, and he believed them. And it turns out that one of them was 13 and the other one was 15. So that's one of those situations where ethically, morally, right, you're presented with something that may bother you, but your job is to make sure that the prosecutor doesn't violate your client's constitutional rights. So to look at the situation as a whole and to try to be as empathic as you can and say, okay, this was brought 3 years later, this dude made really bad decisions, right? But you can't, there's really no way around statutory rape. It doesn't matter that the girls consented. It doesn't matter that they were dating years after that. None of that matters because it was against the law. So that's kind of an example, a real life example of being like in public defense and ethics and morals, and how you have to essentially sometimes put that aside and say, okay, this is my job. In order to do my job, I need to put how I feel about this situation over here and do my job. Another example is discrimination in the workplace. So I am a person of color. I am a feminist. I am very active in a lot of the political movements that are going on right now. And I believe that everybody has the right to express their opinion, and I don't pass any judgment on anyone for whatever your opinion is. I know where I sit, and when experiencing discrimination in the workplace for being different, sometimes you have to stop and say, you know what, I don't want this. This is not who I am. I am not okay with this, and be okay with walking away from the situation and standing up for yourself. And that was difficult, but ethically, right, I know that the people in the company were violating the law. So then you have to go and have a conversation with the appropriate people and say, hey, these people are breaking the law, right? I work with these people, but they're breaking the law. They can't say these things. They can't do these things. and then morally be able to say, okay, I'm putting myself at risk. And at this point, am I going to support myself and walk away as well? Particularly as a lawyer, there are steps that they teach you. It's part of the model code of ethics, where if you have a client and you're telling them don't break this rule, and they're like, I'm going to do it anyway, that you can then request for withdrawal from the court so that you're not put in a compromising position where you are ethically violating your job, right? And that's a little bit different when it comes to public defense, because if your client committed a crime and they confess that to you, you can't disclose that. If your client says, I'm going to commit a crime, I'm going to kill someone, you can disclose that. So there's a variant on it, but that's just my experience.
That's a fine line too, though, because if your client tells you they're just going to go like rob a bank, you can't necessarily disclose that because that's not going to cause harm. It's got to be something that where a person's going to be injured. That whole, when you hear on TV and movies that attorney-client privilege, people kind of think, yeah, what is that really? But it's a serious responsibility that lawyers are given to keep things secret. I mean, if it's a matter of saying, I'm going to go home and I'm going to wipe out my ex-girlfriend's bank account, you can't call the ex-girlfriend and say, hey, change your PIN number. You're not allowed to do that as a lawyer, you know. So, but if he goes and says, I'm going to go home, I'm going to kill my ex-girlfriend so she can't testify, then you can call the police and say, hey, please put a car in front of her house because she's going to die tonight. But it takes a real special person to practice that type of law and be able to realize you may be defending somebody who has committed a horrible crime or a not so horrible crime, but they have that constitutional right to have their rights protected as well. And that we kind of talked a little bit about that with Miranda rights and the fact that you've got a guy who finally admit, yes, I was the person who committed this crime, but the process in which that confession was gained was wrong. So you have to set this person free because you used a bad way to get information. So, and now we'll get into that all in ethics, but Leigh, you share stuff that I could never think of or know, and thank you very much for stopping in again today and giving your insight to everybody. Does anybody have any last questions for Leigh before we let her go? No.
Yeah. So you know how you were like saying about like you know how like in the movies are like sometimes like I don't want to know if you're guilty or not, or I want to know if you're guilty. Like, how do you like, which one do you prefer? You know what I'm saying? Like, I don't know how to say it, but yeah.
So my personal preference would be, I would prefer that you tell me, because then that means I can trust you as a client and I can say, okay, I have the information that I need to represent you and be in your best interest. I think it's harder when you have clients that don't want to be forthcoming with you, because you're going to have a hard time identifying like who's a proper witness and who's not, and who's actually looking out for your client's best interest and who you want to put on the stand. So this might sound a little bit crass, but certain things don't bother me. Like it didn't bother me that the guy had intercourse with the younger girls consensually. I was like, all right, you're just dumb, right? I also represented, he is the kingpin of the largest meth lab in Arizona, right? Represented him. He's a really nice guy, probably very crazy. I'm sure he's killed a few people, but nice guy. And it's very easy for me to say, okay, well, you're a dad, you make bad choices. I still need to make sure that your constitutional rights are protected. I did post-conviction relief. So one of my clients was on death row. He killed 7 people and injured his girlfriend. And we were trying to get him off of death row. So I prefer that you're honest with me, because it's easier for me to then just have the whole picture and say, okay, this is what it is. I will say that I'm fortunate enough that I didn't have to represent someone who was involved in any type of child abuse or child neglect outside of family law, because I think that would bother me. Somebody who, you know, raped or inappropriately touched a child, that I think that would disturb me a lot more versus like the kid that was 19 and the girls. And, you know, like I said, the girls were very much forthcoming. They were like, no, we were consensual. No, that was our boyfriend. Yeah, we lied to him. So I also think that might have been different if he was like, oh no, I knew they were 13. I probably would have felt a little bit differently about this situation. But mostly, for the most part, I'm okay with a lot of the stuff. Thick skin.
All right, any other questions? Okay.
Sorry, I'm asking so many questions. I did have one other question. So you keep talking about all these different committees and things that you're on. So are these things like board member type work, or is this like you're an attorney that's sitting on a group? Like, because I've done some work with like the board of Southwest HIV and AIDS, but not in the capacity of a board member myself, just a lot of like fundraising and event work, but I've been interested in that. And so like, can you explain that and kind of what that time commitment is with your also full-time job, I'm imagining?
Sure. So I actually recently moved back to California. So right now I have a lot of free time. The United States Olympic and Paralympic Committee is the governing body for the team that goes from USA that goes to the Olympic Games. So because of COVID, and with all of the loss of income and revenue from the Tokyo Games being postponed, half of our staff got let go. I was given the option to stay or go, and I chose to go. So now I'm back in California. I'm currently interviewing for different positions. So I'm looking for my next career. Most of the things that I'm telling you about are jobs that I have held. As far as my volunteer work, I'm involved with the El Mar Foundation in Colorado Springs. I was a mentor with Big Brothers and Big Sisters for high school students. I'm involved with Big Sunday. So a lot of the community work I do is very specific to my personal interest and advocacy positions. And the way that I pick them out is by time commitment. Like, how much time do you actually need from me? What are the days that you need, and how much time I can give to them? So Big Sunday, once a month, they have a Sunday event where thousands of people come. We do this big rollout and push out of an event. Everybody benefits, and then that's it. So that one's a little bit easier because once a month, 8 hours on a Sunday is super easy. As a mentor, I was doing 2 to 3 hours a week with my high school students. Super easy. El Mar, every couple of weeks we have trainings on how to be a better leader in the community. So I can take that on very easy. So you look at, find something that you're passionate about, and then find an organization that is willing to say, okay, you can do like a couple hours here and a couple hours there.
And Leigh doesn't sleep much, so it's.
I sleep so much. I have to get 8 hours of sleep, or I'm a crazy person.
So, all right. Well, thank you so much, Leigh, for doing this. And Leigh is going to be back in a couple of weeks to talk about business organizations. So you have not seen the last of Leigh on a Thursday. But I definitely appreciate you taking the time this morning to share all this information with everybody. So we will talk to you soon.
Thank you.
Thank you.
Bye, guys.
All righty.
Bye.